afternoon and welcome to Alternatives to Guardianship Supported Decision-Making 101. Thank you for joining us today. My name is Amy Yedley and my role is the Resource and Development Director for Values into Action New Jersey. We are your hosts for today's presentation. Values into Action is a legacy support coordination serving people with disabilities and their families since 2007. We offer support coordination services statewide in all 21 counties and are currently to accept new presenters in all counties. We at Values into Action believe strongly in person-centered planning and self-directed services. Because of the frequent requests for information that we receive on guardianship, we asked Disability Rights of New Jersey to collaborate with us on this webinar, Alternatives to Guardianship Supported Decision-Making 101. This much needed information to the community. Oftentimes, parents, caregivers, and professionals are informed that guardianship is an option to ensure the safety and future of ones with a disability. This may not be the case. This webinar will review the different options for guardianship and will provide you with information necessary to make an informed decision if guardianship is right for you or your loved one. Joining us, presenters from Disability Rights of New Jersey, who will introduce themselves in the next slide, as well as Pamela King, who is her own guardian and self-advocate who self-directs her services. We at Values into Action are honored that Disability Rights New Jersey agreed to partner with us and thank them for their collaboration. We also thank Pamela King for joining us as our guest speaker. You will learn more from Pam, who chooses not to have a guardian during the presentation. We also have our Values into Action family mentor joining us today, Zinke McGeady. Following the presentation will be a question and answer panel. We have received a list of pre-submitted questions during the registration process from participants. All questions submitted in the chat box will be answered after the pre-submitted questions. You will receive a recording of this presentation and you are welcome to share with others whom you think would benefit. With that, let us get started. Jill?
Thanks, Amy, and thank you for Values into Action for hosting this. I just want to say thanks to everybody who's joining us today. This is really one of our favorite topics, and we're hoping that everybody finds something useful, regardless of where you're falling on the decision-making continuum. So I'm Jill Hogle. I'm the Managing Advocate of our Community Inclusion Team at Disability Rights New Jersey. I'm also going to be joined by Michael Brower, who is our supervising attorney for the Community Inclusion Team at Disability Rights New Jersey. Next slide, Amy. Disability Rights New Jersey, if you don't know or are not familiar with us, we're part of a network of protection and advocacy agencies located in every state who work to improve the lives of people with disabilities by guarding against abuse, advocating for basic rights, and ensuring access to necessary services. We are the federally funded designated protection and advocacy agency in New Jersey, mandated to provide legal assistance and advocacy on behalf of individuals with disabilities through a variety of services, including information and referral services, education and training activities, direct legal representation, and investigation and monitoring. Next slide. I have to take just a moment to plug our DRNJ COVID webpage. Here you will be able to find a variety of resources that we've posted about services at this time during the COVID crisis, as well as all of DRNJ's COVID-related advocacy. In addition, at this site, you're going to find links to all the educational webinars that we've done on topics such as assistive technology services, special education, and all of our DD network town halls. Next slide. So our purpose today is speaking with you all about decision-making from a disability rights perspective. We're also going to hear from our guest speaker, who has firsthand experience, and as Amy said, we're going to allow time for questions and answers at the end. Next slide. So there you go. As Amy said, we have all the pre-submitted questions that you gave us, as well as any questions that come up in the meantime. Feel free to put them in the chat box, and we've allowed plenty of time at the end to cover those questions. Okay, next. All right, so this is our agenda for today. We're going to talk in basics about what a decision is, what does decision-making mean in real life. We'll talk about the legal frameworks that apply to legal decision-making and alternate decision-making in New Jersey. And last, we'll discuss details of supported decision-making and legal guardianships. Next slide. So often the first thing you think of when you hear the word decision is some of those big life decisions. Should I change my career? Should I buy a house? Should I get that surgery? But think of all the decisions, even the smallest of decisions that you've made just today since waking up. You choose what time you woke up, what you were going to wear, what you chose to have for breakfast, if you had breakfast at all. You chose if you were going to leave the house, where you were going to go, and so on and so forth. I can do this for an hour. Your free will is the sum total of all those decisions you make for yourself every day, all day long. You probably gave very little thought about how you came to each one of those decisions. Most of them made unconsciously. But if you really think about each one by itself, you can pick out all the factors, both internal and external, that went into making that decision. What time did you wake up? Well, if you had to get up and go to work, you probably feel you didn't have choice in the time that you woke up. But maybe you did. You could have chosen not to get up for work, but why did you choose to get up for work? Your experience. I might get fired if I don't come to work. What are the consequences? If I get fired, I can't pay my bills. How about what you wore today? Did you just throw on the first outfit that you pulled out of your closet, or did you watch the weather and get some help on deciding what you were going to wear? Maybe you chose an outfit that months ago, back when you could still go to the stores, you were shopping with a friend and your friend said, hey, that outfit's great, looks great on you. Did you eat what you eat every day for breakfast, or did you have to modify that decision because of what was available in the refrigerator? So when you think of all the decisions that you make in a day, think of all the help you actually employ to make those decisions. You use your experience in making the same decisions you've made in the past. You use your knowledge about the consequences. You can choose to use that knowledge, or you can ignore it, like knowing you shouldn't have a second bowl of ice cream, but you have it anyway. You can use the help of others who have more expertise, like the weatherman or your fashionable friend. Okay, next slide, Amy, thanks. So here's some other examples that will help illustrate the complexity of decision-making. So your car stalls on the highway and you're on a road trip. What do you do now? Do you pull the car over? Do you pull on the flashers? Do you call a tow truck? How do you know how to do that? Your experience? Or did you call your dad and he told you that's what you should do? Now the tow truck brings your car to the garage and the mechanic gives you an estimate. Now what? Do you say, okay, go ahead and repair it? Maybe you can't afford it and you decide you have to scrap the car. How much do you trust the mechanic's opinion? Do you have some baseline automotive knowledge to know if he's telling you the truth or he's trying to get over on you? Do you get a second opinion? Maybe all those decisions are just too overwhelming for you and you don't make any of them. Deciding not to decide is still an exercise in decision making. So in about all of these examples that I provided you, you likely used some form of supported decision making to respond to expected and unexpected issues. People use it all the time. Talking to doctors before a medical procedure, talking with friends about taking that job offer, sometimes even with help. People without disabilities are allowed to make mistakes or make decisions without fully understanding the risks. Like getting that tattoo, making a bad investment, or trying out that new fad diet. Decision-making isn't that different for people with cognitive disabilities, whether they're developmental, psychiatric, or brain injuries. The difference might be how much support is needed or how heavily an individual needs to rely on other support to make decisions. Next slide. So I'm now going to turn over to Michael, who's going to take us through some of the legal frameworks of decision-making and supported decision-making. Okay, Michael, thanks.
Thank you, Jill. And thanks, Amy and Zinke, for hosting this really exciting topic. Like Jill said, something that we talk about all the time, and it's nice to be able to bring it out and talk about it with a big group of folks, even if it's virtually. Next slide, please. So I'm going to be talking about the legal frameworks for this decision-making process in New Jersey. A lot of you probably signed up because you saw supported decision-making in the title of the webinar, and you thought, I wonder how that works in New Jersey. Some other states have statutes or laws that govern how they operate a supported decision-making network. The way Jill just described the decision-making process, though, is how it works in New Jersey. We don't have a supported decision-making statute. We don't have any supported decision-making regulations. So essentially what it comes down to is an informal process where folks make decisions and set up their own supported decision-making networks however they see fit. And that goes across the board, whether you have a disability or don't have a disability. You can lean on whatever support you want or need to make a decision. We call it ad hoc support. You make it up as you go along. Just because we don't have a statutory framework for supported decision-making doesn't mean we live in the Wild West. We're going to talk about a couple of different laws and a couple of different court cases. I'm a lawyer, I can't help it, that are going to give us a little bit of boundaries and a little bit of guidelines to work within. The one thing I want to talk about right off the bat, and it's important to think about in any context, especially if you identify as a person with a disability, the Americans with Disabilities Act and New Jersey has a state law called the Law Against Discrimination. Both protect against discrimination by places of public accommodation, and that might be, a mall, a doctor's office, a lawyer's office, could even be someplace like an apartment building, where discrimination against people with disabilities is prohibited. And in order to effectuate that, the laws require some kind of reasonable accommodation. The easy thing to think about would be a ramp in front of a publicly accessible building, so that someone who uses a wheelchair could get in and out and is not precluded from using whatever services are inside that building. When we talk about decision-making, a really common question that comes around when we talk to clients or people who call disability rights for assistance is, my doctor's concerned that because of my disability, I can't understand a medical decision and therefore I can't give consent for a procedure that I really need. I've got cataracts, I need surgery, and the surgery center just won't approve me because they don't think I understand all the risks. A lot of times doctors will cite liability. Doctor is concerned if my patient doesn't understand the risks and they can't consent, what if something goes wrong during the surgery and that patient comes back and sues me and said, I didn't understand what you were going to do to me and you didn't warn me. Liability is a big concern. I'm a lawyer, so I live in the world of liability where people get sued for money and they're concerned about it. They don't like that. It's not pleasant. Something to consider is under the Americans with Disabilities Act and New Jersey's law against discrimination, if that doctor refused to treat a patient because they had a cognitive disability, might they be creating a new set of liability for themselves? Are they discriminating against that patient? What kind of accommodations might they have to set up? Would they have to explain the process in terms that are understandable? Maybe they have that person bring in a supporter who can help them understand and speaks their language. It's easy to think about somebody who's deaf and uses American Sign Language. It's clear cut in the law that that doctor would have to work with an American Sign Language interpreter to make sure that the patient understood what was going to happen and gave consent. Is it all that different for somebody with an intellectual or cognitive disability? I don't think so. Next slide, please. And again, just because we don't have rules and laws that are on the books in New Jersey that cover supported decision-making doesn't mean that the rest of the world doesn't have something to say about it. Chapter 12 of the United Nations Convention on the Rights of Persons with Disabilities, it's a long name, that says that states shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. This includes the right to support to exercise legal decision-making capacity. So in those advanced countries that adopted the United Nations Convention, they have laws that are enforceable and on the books that say people with disabilities in those countries need to be provided with support so that they can exercise all of their decision-making power, just like somebody with no disability whatsoever. Of course, the United States doesn't join that cadre of advanced countries. We signed the treaty, but the United States Senate never ratified it, so it doesn't have the force of law here. You'll see on the map that's up on the screen, there's countries in blue that have ratified that law. There are countries in yellow that signed it but never ratified it, and you'll see it's a pretty small number of countries. It's not a great club to be in. One of them is North Korea. Next slide, please. What we do have in New Jersey is a guardianship statute. We also have regulations and court rules that frame guardianship. There's a couple of really important statutory excerpts up on the screen. Before I start getting into the legalese and the citations, I want to start with a really basic concept. The really basic concept is that in American law, the state, the individual state, when I say state, I mean New Jersey, Pennsylvania, Delaware, an actual state, has a basic fundamental principle to take care of the people who live within that state. And as part of the exercise of that authority, states from the time the country was founded took a role in making sure that people with disabilities weren't exploited. It was a very different world back then. And the things that we deal with in the modern world probably couldn't even be comprehended by a lot of the folks trying to think ahead. But all of our guardianship laws and statutes come out of that basic thinking that the state needs to take care. It's a patriarchal, a parent role of the state over its children, the people of the state. So there's a few, like I said, of really important statutes that have come out of that history, and they're up on the screen. The one I want to focus on first is the standard for when does somebody need a guardian. In New Jersey, we call that lacking capacity or having incapacity. Under our statutes, somebody lacks capacity when they can't govern themselves or manage their own affairs. Does that tell you anything about when somebody actually needs a guardian? Doesn't tell me a whole heck of a lot. This is really, in practice, a subjective standard. The way that you find out, or the way the court would determine that somebody lacks the capacity to govern themselves or manage their own affairs, is that they receive a filing from an individual who's concerned that comes with a certification of 2 doctors that certify that that person lacks capacity to govern themselves or manage their own affairs in the opinion of those 2 doctors. That's all it takes. There's a couple of cases also up on the screen. One of them is called In the Matter of MR. We're going to talk a lot more about this later. It's a really important case. But for now, it's good enough to know that the law in New Jersey, both from that case MR and under the statute, requires judges to consider, once they've heard that somebody lacks capacity and needs a guardian, they should consider whether that person needs a limited guardianship first. If the limited guardianship would suffice, that means that person doesn't need a general guardianship. The court is supposed to go through a process where they review all of the different domains of decision-making and only appoint a guardian when somebody who lacks capacity needs a guardian in those areas. Those areas are also up on the screen. Residential, choosing where to live; educational, choosing whether or not you go to school or where to go to school; where you get training for the job you want; medical decisions, having a procedure done; consulting with a doctor, giving consent for organ donation and things like that; legal decisions, whether to hire an attorney, whether you're going to sue somebody; vocational decisions, where you're going to work; and financial decisions, whether you invest your money, whether you spend it all on yourself, whether you save up for that big vacation, or whether you save everything for retirement. These are the different basic domains, and you can take any one of those and break it down further, but these are the ones that are laid out for the court to consider. In every guardianship, it's supposed to consider each of those separately and only appoint a guardian for those areas where it's necessary. Next slide, please. Remember on the last slide when I said the standard was pretty subjective and it really only required the certification of 2 doctors? Up on the screen is a picture of a wide paintbrush. I'm going to call it a broad brush. Since 2016, The standard has gotten even lower for adults who qualify for services from DDD. That's the Division of Developmental Disabilities. For anyone who qualifies for DDD services, in 2016, the rules were changed. Now there only needs to be one physician or one psychologist certification that the person lacks the capacity to govern themselves or manage their own affairs, as long as that one certification is accompanied by a certification from an administrator of a DDD program, a DDD officer, a licensed care professional, or even just a copy of an IEP from someone was in special education within the last 2 years. So the reason I've got that wide brush is that folks who receive services from DDD are painted with a broad brush. It's a little easier to get a guardianship over somebody who's in that system. It requires less scrutiny from the court to determine whether or not they actually could make their own decisions. Next slide, please. All right, so we've moved through some of the legal frameworks, and I've given you a pretty bird's eye view of what we're working with as far as the rules. Next, I want to start talking about some specifics about supported decision-making and guardianship. Next slide, please. The first thing I want to talk about is reaching back to the process that Jill described, the kind of informal supported decision-making process. Do you call your mom if you're wondering what you should do about that job offer? Do you talk it through with your spouse before you decide to have a major surgery? Do you call your best friend if you're not sure what you're going to wear on a date? When do you reach out for that kind of help is up to you. You might even have a written agreement where you say, I'm always going to talk to mom, and mom is always going to be on call if I've got something big going on with my career. That could apply, again, regardless of whether or not you identify as a person with disabilities. You might also do something a little bit more formal. We're not going to get into great depth on powers of attorney or healthcare proxies. There's another presentation up on our website about that if you want to learn more there. Just know for now, those are more formal ways to designate somebody to make decisions on your behalf. That's a little bit different than supported decision-making. In supported decision-making, you always make your own decision. You might ask for help, you might ask for input, but you're always ultimately going to be the person making the call at the end of the day. If you're that person with the car in the shop, you're going to tell the mechanic what to do. Dad's not going to get on the phone and tell the mechanic what to do with your car. But if you've got the ability to either appoint someone to make a decision for you or to call for help when you need help on something, and again, whether that's informal or formal, might that be a defense to whether or not you're capable of managing your own affairs? Maybe you can't quite understand all the medical lingo that your doctor's telling you about the complicated eye surgery, but maybe when you talk to your mom and your dad, or you talk to your best friend, or you talk to your support staff, you can understand it. Okay, we've broken it down into terms that make sense. Can't you actually manage your own affairs if you're using that kind of a help? I know I certainly can't file my taxes on my own. I call an accountant. I don't think I'm incapacitated, but with the help of the accountant, I can understand enough to know I filed my taxes appropriately. And the other question is whether the facts of a less restrictive supported decision-making arrangement, again, whether that's formal or informal, could be presented in court. If somebody wanted guardianship over another individual, and that individual said, no way, I don't want a guardian, I can make my own decisions, I just need help. Those kind of facts might be a good defense to the basic question of, does this person actually lack the capacity? Next slide, please. Then there's the question, let's say that even that's a foregone conclusion. Maybe somebody does really lack capacity. It's kind of a question because it's such a subjective standard. And I tend to lean on the side of the spectrum that says probably a lot more people have capacity to make decisions than we give them credit for. But let's take for a second that we've already gone through the guardianship process and we're talking about an individual who already has been found to lack capacity. The court has used its parental powers to appoint a guardian to make decisions on behalf of that person. There are still duties within New Jersey statutes that require some level of, they never use the word supported decision-making, but some level of decision-making inclusion from the guardian to include the person who lacks capacity. So I put up on the screen a list of the different duties a guardian has, and the statute says they shall do these things. It doesn't say the guardian may do these things. doesn't say the guardian can do these things, or maybe they'll think about it. It says the guardian shall. So that means that even though a court has judged someone to lack their legal capacity, the guardian still has a duty to engage that person in the whole decision-making process, to respect their preferences, and to help the person learn to make decisions as much as possible. That doesn't mean that once you've been, so basically what that means is once you've been found incapacitated, the guardian should be working actively to bring you back to capacity as much as possible. Maybe that means including you in financial decisions, teaching about how to budget, how to plan for the end of the year so that you can have enough money to get through all the needs you have. Maybe that means learning a little bit about, how to call on help so that you can, formally or informally, use a supported decision-making network that'll help you get you through decision-making processes so that at some point in the future, whether that's soon or whether that's long, you could go back to the court and ask your court to restore your capacity. We're going to talk about that in just a second, but keep that in your mind. Restoring capacity is a possible thing in New Jersey's legal system. Next slide, please. I told you I couldn't help myself, and I can't. There's a couple of court cases that are really important to know about. Both of these cases that I'm going to talk about came from New Jersey's Supreme Court at the state level, meaning they're the law of the land in New Jersey. These are some really good cases that discuss the rights that people retain even if they're subject to a guardianship, even if they've been found to be generally incapacitated, meaning the court has gone through the analysis and all those different domains of decision-making and found that somebody doesn't have capacity in any of them, generally incapacitated. The first case I'm going to talk about is up on the screen now, called In Re Grady. Give you a quick background on the facts. Grady was a young woman with Down syndrome. She was an adult and her parents were appointed as her legal guardians. They got along pretty well. There wasn't really any big issue, but Grady was a young woman and she wanted to date and she wanted to have sex. Her parents thought this was a good idea. None of them, though, wanted her to have a child. She didn't want to have a child. Her parents didn't want to raise her child if she became pregnant, and they were concerned, and she was concerned that she couldn't always remember to use birth control. They decided that a sterilization procedure might be appropriate, and it's worth a little side trip here. There's a nasty history with involuntary sterilization of people with disabilities, going back to a long part of American history. We're not talking about that here because this is voluntary, where the person wanted it for their own benefit and their guardians also wanted it. So it's a little bit of a sidetrack, but that history hangs heavy whenever you talk about sterilization of people with disabilities. You need to acknowledge it. They took her to the hospital. The guardian said, here's our daughter. She wants a tubal ligation, so she doesn't have to worry about ever having kids. She doesn't want kids, and she would like you to perform the procedure. Hospital said, well, wait a second. She's got a guardian. We can't give her this procedure because she can't consent. And you guys, as the guardians, we don't think you've got the right to consent on her behalf. Essentially, hospital's saying, we're going to deny her this medical service that she wants and that her guardians want because she has a cognitive disability. The family went to court. The guardians went on her behalf. They went through the trial court. They went through an appeal court and eventually ended up in front of the Supreme Court in New Jersey. And the Supreme Court said that in an attempt to balance the right of the incapacitated person to receive these services with a right to be free from involuntary sterilization, again, that's that heavy history we're talking about, courts need to make specific findings supported by clear evidence that an individual lacks the capacity to consent or to withhold consent. Only then should we turn to the guardians or to the court to determine what's in her best interest. So the court's really saying we need to look to the person first. This is a really intimate, personal decision. She's deciding whether or not she's going to have children in the future. If the court is already gone through kind of the general domains of decision-making, I said, those can be broken down. Here we've got some subset of the healthcare decision-making process that's so important and so intimate that the Supreme Court of New Jersey says we need to ask her. This is her decision to make. And only after we've asked her and determined that she doesn't understand the decision she's making, only then do we turn to the guardians or to the court to decide what's in her best interest. First, we ask her. This places a lot of power back in the hands of a person with disabilities who's got a guardian who disagrees with their guardian. Because if they hadn't been in agreement, if she didn't want to be sterilized, but the guardians wanted to sterilize her, and they had gone to the court and the court came with this answer, We would throw what the guardians had to say out the window to start with, and we'd start with asking her. This is huge. We're going to go from there. We're going to build on that with one more case, and I promise this is the last case I'll talk about. Next slide, please. The next case is in the matter of MR. So Disability Rights New Jersey and its former incarnation as New Jersey Protection and Advocacy, and some of our old bosses, were heavily involved in litigation in the matter of MR. If you read no other Supreme Court case, I know they're dry, I know they're boring. If you've got a little time in your hands, and I know we're all spending a little social distancing time, now might be a good time to go get a copy of MR off the internet. It's available for free, and give it a read. Here's the basic facts. There's a guardianship dispute. Two parents of a disabled child have been divorced. They have an adult daughter who's got disabilities. One of the parents is a fun parent. One of the parents is a structured parent who wants services. And the question is going to be, which one of these parents is going to serve as MR's guardian, because they both disagree that the other one should serve. Each one wants to be her guardian. And the assumption is whoever is the guardian is also going to make the decision where this adult daughter will live, and they each want her to live with them. MR had a preference for which parent she wanted to live with, and you can probably guess whether it was the fun one or the structured one. And this matter ended up in court because the dispute could not be resolved between the people themselves. Again, they go through the trial court, they go through the appeals, they eventually end up before the Supreme Court of New Jersey. And the Supreme Court of New Jersey says, pulling from New Jersey's Constitution, which contains an inalienable right to self-determination, and leaning heavily on the decision from In re Grady, the court finds that when a decision increases its importance, so should the right of the affected person be to make that decision. Our goal is to permit developmentally disabled people to make as many decisions as possible while protecting them from the harmful effects of bad decisions that they do not fully understand. So again, we're taking that concept from In re Grady. We should give people the right to self-determine, to make decisions for themselves. The more important the decision is, the more we should listen to them first. And only after we've decided they really don't understand the effects of a decision should we start to turn to other places for a different person to make that decision for them. Again, this is a big holding. This places a lot of power into the hands of somebody who has a guardian, even if the court has already determined that that person generally lacks capacity to make decisions for themselves. We're turning back to them and giving them rights to make big decisions and asking them first. Another big part of In re MR is that whenever there's a challenge and a dispute between the person with a disability who's subject to guardianship and their guardian, the person who wants to limit the person's right of self-determination bears the burden to prove that that person is unable to understand the decision that they're making. This means that when they're in court and MR is having the fight with the mom or the dad and expresses opinion, I want to have dad serve as my guardian and I want to live with dad, that starts as default correct. The court will accept that as true and well-reasoned until somebody else proves that she doesn't understand what she's saying. It's as if I ran over Jill's foot with my car and she sued me in court. She bears the burden of proof. If she can't prove that I ran over her foot, she loses. The same thing happens in the guardianship world. If you can't prove that the person subject to the guardianship doesn't understand the expression they're making, the expressed wish that they're making, you lose. And the person's expressed wishes should be carried out. The standard is clear and convincing evidence. It's really a legal topic. What it means is you need to have clear and convincing evidence. You need a big mountain of evidence that by itself looks like really can't be disputed. And that burden to pile up all that evidence is on the person who's trying to take away the right of the individual subject to the guardianship. Next slide, please. Again, this case applies even if somebody's already been found to require a general guardian where they don't have decision-making powers in any individual category. And even more so if somebody has a limited guardian, where the guardian only makes decisions in certain domains of decision-making. Another takeaway that's worth knowing is that there's a difference between the individual's expressed interests, what they say they want, versus their best interest, what's objectively, quote, good for them, unquote. people with disabilities who are in a dispute with their guardian have an enforcement mechanism that the court has put in place. I've put the court rule up on the screen. And basically what the court rule says is that an incapacitated person, no matter how they've been found incapacitated, no matter their history, always, always, always retains the right to consult privately with an attorney to either review the guardianship's actions to help them file in court, or to hire an attorney to fight for their specific expressed wishes if they disagree with their guardian's decision. What that means is that if somebody's locked in a dispute with their guardian, the place to resolve that, if the dispute can't be resolved between them, is in the guardianship court. In New Jersey, we call it surrogate's court. And the individual with disabilities is always entitled to talk to an attorney privately to help them get into court so that all of these standards that I'm talking about can be applied. Because it's in a private conversation between a guardian and the person who's got incapacity. If they disagree, these standards may never even be considered. In a court of law, however, a judge and a lawyer can bring these cases together and make sure that they're going through the process first. That means the more important the decision is, the more we're going to look to the person with disabilities to make it, unless, by clear and convincing evidence, the person who wants to take away that decision from the person with disabilities can prove they don't understand it. I said we're going to talk about restoring capacity. We got a lot of pre-submitted questions about that, so I want to move on to that. It's one of my last main topics to hit before we start going in and have Pam come on the screen. So I want to cover that and move along to the next section. So please go to the next slide. All right.
Okay, I just got, sorry everybody here. You didn't lose the audio, Michael lost his power. So unfortunately, what we're gonna have to do, Amy Zinke, is let's go, he's gonna be rebooting. So yeah, everybody's having some strong storms. So apologies, everybody. There's just going to be a little bit of a break here. Hopefully we can get Michael back on. And if not, we'll just change up the order and go to Pam first. Do we have Zinke?
Sorry about that.
Oh, great.
Okay, so I'd like to introduce Pam King. Pam, you're going to read your presentation and then we have a few questions for you.
Okay. Hello, I am Pamela King. I live in my own apartment with my dog Lucky. I have nice neighbors and a great pool. With support, I pay my bills, plan, shop, and cook my meals. I see a lot of doctors and take care of my medication. I have a job that I hope to get back to soon. I am a proud 2018 graduate of Partners in Policy Making. I am my own guardian. I use supported decision making to help me make decisions and choices. This includes my circle. Members of my circle support me by explaining confusing things, giving me information, sharing their ideas, and talking to me about my ideas. You may have people in your life like this too. Members of my circle include my mother, brother, and aunt, my diabetes educator, and Dr. Freeland, and wonderful people from agencies like Ashley and Zinke from Values into Action, Natalie and Joan from Avenues to Independent Living, Jamie from Camp Sun and Fun, and Amy from Ability Solutions. My circle can change because I can change, and so do the decisions and choices I need to make. With support, I am making a section on my computer for my circle. In it, each member will have a page that includes the name, contact information, how I know them, and what types of things they usually support me with. We also working on an invitation to invite members to be part of my circle. The invitation will explain that being part of my circle includes assisting me in understanding, considering, and communicating decisions and choices. The invitation will let them know the type of support I am looking for from them. It is up to them to accept the invitation, but it is up to me to invite them. I have other supports like medication pill packs, Alexa and iPhone apps, Access Link, Uber and Lyft. I also love to look things up on the internet and learn as much as I can on my own. I am proud to be my own guardian.
Excellent. Thank you, Pam.
Oh, you're welcome.
So one of the first questions is, has there been challenging times where you thought this wasn't working?
During a long hospital stay, hospital staff did not always listen to my mother because she didn't have guardianship.
Okay. And has it been tough at any other times?
During COVID, it has been hard for support people to come with me to doctor visits. This support is important to me.
What makes it different for you that you do not have a guardian?
I have never had a guardian, but I do know I like making my own decisions about things like where I live, activities I do, medical choices, job choices, and many other things.
What advice would you give to someone looking into and thinking about guardianship?
You have other options and rights. Consider supported decision making and to take a look at your own circle.
Excellent. What do you think is important for other people to know about guardianship?
You have other options and rights.
Thank you, Pam. We're back to Michael and Jill.
Hey guys, sorry about that. Right in the middle of putting a picture of a Pittsburgh Penguin up on the screen, my power went out. I guess that's the lesson I should learn from that. Could I ask Amy for you to go back to that slide real quick? Maybe I won't tempt the fates twice, but maybe I will. Okay. Mario Lemieux's on the screen and my power's still on. I guess this is okay. And thanks, Pam. I appreciate you covering for me there while the power came back up. So last slide here, and then we'll open up, I think, for question and answers after that. You know, though it's relatively rare to happen in New Jersey, we've got a lot of questions, and it does happen, where individuals where the court has found they lack capacity can be restored back to their full legal capacity. I give a story here just to kind of demonstrate how things can go bad and go well. You know, Mario Lemieux is up on the screen. He's a hockey player for the Pittsburgh Penguins through the 90s and the early 2000s. He actually retired in 1997. He had gone through years of treatment for Hodgkin's lymphoma. He had a herniated disc in his back, chronic tendonitis. The guy could barely walk, so he had to retire from hockey. Only 3 years later, though, after beating cancer, he comes back to the NHL, and everyone thought, okay, well, he's washed up. He played for 5 more years, had several MVP careers, or MVP seasons, made an Olympic appearance for Team Canada, and had a close call with another Stanley Cup. The proof of his ability to come back was in his ability to play top-tier hockey. Nobody said he's going to make it. Nobody thought he could make it. He did it. He proved to everybody that he could come back, and he was restored. He was the hockey player he had been before, and then some. The same test is something that we look at when we talk about restoring folks to legal capacity. The legal test, the standard, is exactly the same as the test that we use to determine if somebody has capacity or not in the first place, whether they can govern themselves or manage their own affairs. That standard doesn't tell you so much, and you know, you could have 2 doctors certify that you could govern yourself or manage your own affairs. And if everyone agrees, maybe that would be enough on its own. If your guardian thinks you've been restored to capacity, if you think you've been restored to capacity, 2 doctors agree you've been restored to capacity, that you can make all of your own decisions, that might be enough to get you by. But if that's contested, if the guardian doesn't think so, or somebody else doesn't think that you're restored back to capacity and they want to fight it out in court, the proof is going to be in the pudding. Have you developed a supported decision-making network? Have you built yourself up a good track record of considering decisions, asking for help when it's needed, and making good decisions and considering risks? We talked about how people don't always make good decisions. That's okay to make a bad decision. Did you learn from an error? Those are the kinds of evidence that go the furthest if there's a contested restoration of capacity. I put up on the screen a court rule again. This is the rule that allows people who have been found to need a guardian to always have the right to go back to court and ask the judge to restore their capacity. Again, you're going to want to make sure that if you do that, you're going to go to court with good, solid evidence, the letters from the 2 doctors, and a good track record that you can tell a story to the court that explains you can make decisions without a legally appointed guardian. When you need help, you can ask for help. You know who to ask for help. If you make a mistake, you learn from the error. Those are the kind of things that a judge is going to look for. So with that, I think that I've got nothing else affirmative to add. If we just go to the next slide, I want to see if we can put disability rights contact information up. Perfect. Thank you. Obviously, we're talking very generally about the law. If you have a question about guardianship that's specific to you, we want to answer general questions here, but anything that's really specific to you, we don't want to give legal advice in a public forum. The contact information is up on the screen. You should be encouraged to contact Disability Rights New Jersey. We can do an intake and give you some advice about what might be going on in your case, hear from you, and see if it's something we could do to help. So while we leave that up, that's the end of my presentation. Thank you.
Thank you, Michael. Thank you, Jill. And thank you, Pam. And thank you, Zinke. Moving on to the next portion of the webinar is the question and answer panel. We have about 50 pre-submitted questions, some of which are duplicates. So I'm going to read those and then we'll get into the chat. The first question we have for Disability Rights New Jersey is, what is partial and limited guardianship?
All right, I'll take that one, I think. So the question was, what is a partial or limited guardianship? I just want to make sure I heard you right, Amy.
Yes, that's correct.
Yeah, so a limited guardianship is where the guardian is appointed only to make decisions in certain life areas. So for example, if somebody just has a hard time understanding dollars and cents, budgeting, making sure that they're making sound financial decisions, but everything else they've got on lock. They can either call for help or they can make the decision themselves with some level of support or with no support. Then a court should be going through one by one and only appointing a guardian where that person needs a guardian, and that would be the financial. So there could be a limited, and we see this with some regularity, that usually is the most common area because it tends to be pretty complicated, where a court has appointed a limited guardian only over finances, where the guardian only makes decisions about money. And everything else, where to live, where to work, who to associate with, what kind of school to go to, that all is left from the outset in the hands of the individual and not in the hands of the guardian.
Thank you, Michael. The next question is, what if an individual wants to be a self-guardian, but their parent refuses to give up guardianship?
So with this one, I think that's probably the last part I was talking about with my restoration of capacity slide. Mm-hmm. Ultimately, because all this traces back to the historical kind of parental powers of the state, that decision always lies with a judge. So if there's a dispute, or even if there's agreement between the person and their guardian, the judge ultimately has to make a decision about whether or not that person still needs a guardian. And a judge might make an adjustment. It might be something in between. They may say, okay, well, I can see that you now understand medical decisions, or you have a good network to support you in making medical decisions, or maybe you've gotten much better at math just by having a lot of time to practice and now you can budget. A court may go from a general guardianship and reduce it to a limited guardianship and give the person specific powers back. Or the court may go all the way and say, no, you don't need a guardian at all, and give the person back their full decision-making power. And that all, like I said, that all goes before the court, and it's about producing evidence. Usually it's 2 letters from doctors plus a good track record or some demonstration that you know how to make decisions now if you didn't before. Or maybe that the court got it wrong in the first place and you've been making those decisions the whole time. That happens too.
Perfect, thank you. That leads to the next question. How difficult would it be to reverse a guardianship?
It can be tough. I have to say, there's a predisposition. If anyone in this webinar has ever been to another presentation about guardianship, you've probably noted very few of them come at it from this angle. Most lawyers in the state or legal services agencies are going to talk about how to get a guardianship. There's a lot of current or momentum towards being protective and being cautious, and giving somebody the freedom to make a mistake isn't being cautious. It sounds risky. So there usually has to be a good set of evidence. Again, the track record is going to be one of the stronger things. Look, I've got some examples under my belt. I've worked with an agency to help me understand my bills every month. I've managed my funds. I've got a formal decision-making network set up, or when I need help, I know who to call. I've got written down on a paper, and I've got agreement from those folks that they'll help me, but they're not going to make the decision for me. Or if you've got a guardian who's really following all the rules and who's been actively helping you the whole time to work back towards restoration of capacity, that's another good place to come up with that track record. If you don't have those things, it can be pretty tough, because judges don't want to, and literally set somebody free and have something come back that they find out later, oh, that was the wrong decision. They're very, very cautious once they've set somebody up in a guardianship. Another good reason when folks are asking questions about, when should I get a guardianship? Should I jump right into it? Is it necessary? Think carefully. If you're, for example, the parent of a child who's about to become an adult, or if you're the person with a disability and someone's talking to you about guardianship and you just kind of say, whatever, I'll deal with it later. Once you're in, very, very difficult to get out.
Thank you. And when should that process begin? We have a few questions pertaining to this. Is it age 18, 21, 25, or 60?
Jill, do you want to take that one?
Well, I mean, generally, a parent is a decision maker until the individual turns 18. So if you're in a situation where a guardianship might be the right course of action, or a limited guardianship is something that both of you are considering, I would say probably 18 is the target age. You mentioned 60, and that's for, you're talking about elderly, establishing guardianship for elderly, I think. And so I don't know that I can speak intelligently on that end of the spectrum, but
there's one thing I want to add to that. I think, maybe it identifies me as kind of my bias on these issues, but there may be, no number that says like, this is when you should go get guardianship of your loved one. Maybe it's worth considering, could we use supported decision-making first? Could we try this out for some period of time? Again, I don't identify as a person with a disability myself, but I know that when I was 18, I made a lot of bad decisions, right? Like I did some stupid stuff that I look back on and I think, wow, how did I even make it out alive? Let alone, end up with a job in a house like that. It's crazy. It's absolutely crazy. So anybody who's 18 is going to make some strange decisions, but by having, if there's strong family support, where if there's somebody considering guardianship, presumably that person's really involved in your life, that might be a good time to start, if you haven't already, start developing decision-making a process. Even if there's going to be a guardianship, even if you're going to go seek guardianship, it might be the right time to also start thinking about supported decision-making, so somebody's not locked into a guardianship for the rest of their life, because it's easy to go from age 18 and you blink and next thing you know, you're 60 at the other end of that spectrum, and you've never made a single decision because your guardian has always made those decisions for you, and you've never made a single one. It's awfully tough to learn how to do something if you never try it.
That's it.
Thank you. Is it possible to make guardianship more affordable for families? And can you share or recommend referral sources for pro bono guardianship services?
I don't have any good referrals, and I probably wouldn't point you to one particular attorney or office that does a really good job with guardianship or not guardianship. And as far as affordability, it's a court process. Anything that goes through court is going to cost at the bare minimum filing fees and some time. So I don't know if I've got a great answer for that. Other than it's good to talk to more than one person. Interview, if you're going to consult an attorney for anything, you always want to interview a couple of people to make sure you've got somebody you're comfortable working with. Other than that, I don't think I've got any specific advice.
Next person actually asked, what is the filing fee for processing?
Oh, what is the filing fee? I'm not a huge proponent of, you might be able to tell by now, of going and filing for guardianship. So if you're thinking about filing for guardianship, I would tell you, you can look it up on the court's website. They also change from time to time, so I don't want to spit something out that's a couple of years old. But I think you measure it in hundreds of dollars. I don't think it's not super expensive. It's not super cheap.
Is it possible to obtain without having a private lawyer?
That one's an easy yes. Yeah, for most court processes, you don't need a lawyer, meaning it's not required that you have a lawyer to get into court. That being said, at the same time, it's also almost always a bad idea to go into court without one, even though you're allowed to, because there's a lot of rules, and you saw some of them go by on the screen. If you don't understand all of them, you might step into a trap of some kind or make a mistake, or you might consult with an attorney who tells you, look, you're filing for guardianship for somebody who maybe doesn't need it. This might be something where you guys could consider maybe just setting up a power of attorney or coming up with a formal agreement that would support decision making. That's a good filter because you can talk with somebody who's seen a bunch of cases and they might be able to point in the right direction.
What is the difference between being a legal guardian versus power of attorney in terms of decision making?
All right, so this one's actually a pretty easy answer. So being a guardian, you're wielding the power of the state. The state has said you will act and make decisions for this other person. When you're a power of attorney, you're not wielding the power of the state, you're wielding that person's power. It's the power has been transferred from the individual to the power of attorney. And, you know, that's good and it's bad. The word is really concurrent powers, meaning they run at the same time. The person doesn't have to be incapacitated to appoint a power of attorney. Plenty of very wealthy folks who travel all around the world for business will appoint a power of attorney to handle their affairs at home while they're off, you know, jet setting and making, you know, bajillions of dollars overseas. You know, there's no question that those folks, you know, have capacity or not. So it's not a prerequisite that you don't have capacity. For somebody who, you know, isn't in that set, they're not the billionaire flying overseas, but they just want someone to make a decision for them, they can appoint a power of attorney, and they can also revoke that power of attorney anytime they feel like it. So they can give the power and they can take it away. There's no court involvement. It's only the person and the person they've appointed to be their power of attorney. The difference between a power of attorney and a supported decision-making arrangement, whereas in a supported decision-making arrangement, that supporter helps the individual themselves decide. In a power of attorney arrangement, the power of attorney has been given the green light to decide whatever's written down in the power of attorney, whether that be financial, medical, you know, legal transactions, anything like that. You can basically designate what powers you want to give, how long they last, and you can also terminate it anytime you feel like it's not appropriate anymore.
What is the difference between a conservatorship and a guardianship?
In New Jersey, there's not much use of conservatorship anymore. It's a kind of an old-fashioned system. It was meant for those people who just need someone to control their money to stop it from being stolen. You know, somebody could be taken advantage of. But for the most part now, my understanding is that folks use guardianship with a limited powers over finance instead of conservatorship. Getting into more detail, it's going to be a really splitting exercise in splitting hairs, I think. So that's probably the simplest way to put it.
As a guardian, are we responsible for any consequences of the person we have guardianship over?
It's So this question's a little, you're responsible for the person to make the decisions for them and to act in their best interests at all times. And you're also, definitely responsible to follow those rules I had up before about involving them in that decision and whenever possible, having them decide and respecting that decision. This person might also be asking about like liability, and putting on my liability hat as a lawyer again. Would I have to dip into my own bank account to pay if I have guardianship over my son, he crashes a car into somebody else, would I have to pay? It's a really big question. The answer is most of the time probably not, but it depends. Fact-specific situations require analysis. I would always tell you, if you have a question about that, if you're concerned that maybe you've got liability for somebody you're a guardian over, you may want to consult a private attorney to talk about what your rights and responsibilities might be to make sure you're making a decision, or at least you understand what your responsibilities might be. Exercise a little supported decision making there, I think might be the right thing to do. And talking with an attorney who does this stuff would be the way to do it.
What qualifies somebody as being incompetent to sign legal papers?
So that standard goes back to the same capacity standard that I was talking about before. Whether somebody can manage their own affairs or govern themselves. If there's ever a dispute about whether somebody understands papers they want to, and somebody else says, no, you can't, you don't understand these. Like a lot of things that are in our state, that means you're going to end up with a dispute that ends up in front of a judge who's going to make a decision about whether that person has capacity or not to do that particular item.
What do I do if my adult child needs guardianship but doesn't agree to it?
Talk with them. Why don't they agree? I think that's a great time to have a conversation about where the disconnect is. It could be something where they totally don't understand the concept. It could be something where they've got really strong feelings about self-determination, and they don't want to be on the receiving end of all their decisions instead of on the giving end of all of their decisions. But it's a really, it's a good time to have that conversation before you're in court fighting about it, because the person who's going to be subject to the guardianship, when they go through the process, the court will always appoint them an attorney, and that attorney's job is to listen to their expressed wishes and advocate for them. So if they end up in court and they tell their lawyer who's appointed, I don't want a guardianship, that attorney's job is to fight against the guardianship tooth and nail, and find any evidence and present any evidence that says this person can make their own decisions. So unless you want to be having a legal battle with your loved one, it's probably good to talk about that ahead of time and understand where they're coming from. Maybe you realize that maybe I haven't given them enough credit. Maybe they do want my input, but maybe they want to be the captain of their own ship. I think that conversation would be really healthy to have at a time like that. That's not a legal answer. That's just a human answer, I think.
Yeah, Michael, and I just want to kind of piggyback off of something that you said before, that even if before you get to that point, if you're you and your loved one are practicing making decisions, if you're giving opportunities and allowing for the individual to make decisions, having that conversation, there's going to be a lot more context to that conversation for the both of you. The individual with the disability may be able to come back to you and say, hey, look, I've been able to make some of these decisions, and I've, maybe I made a mistake here or there, but all in all, I've made pretty good decisions. Or, conversely, you may be able to, explain these were some of the consequences of really not good decisions that you made. And, using both of those sides to have the conversation with each other.
And building even further, Jill, I think it makes sense to go back. A lot of times these conversations are had when, especially it's a student with disabilities who's getting special ed services, is either getting close to graduation or getting close to their 18th birthday. All of a sudden it's like, we have to do something about this, or we're about to cross a legal threshold. This person's about to become an adult. What should we do? It all starts a lot longer before that. Thinking about this in advance. Most parents are going to be teaching their children along the way, some moral compass, some way that you use decisions. Do we talk about things as a family, or is there like a tyrant in the household who decides everything and we all just listen to them? Polar opposites, and there's everything in between too. But the earlier and the further in advance, especially if you're concerned about your son or your daughter and how they might make decisions once they're an adult, the earlier you can start to feel out this decision-making process, the more time you're going to have to both get to know their ability to make decisions and also maybe train them up, get them up to speed to make, even if it's at a basic level, know when to ask for help on things, know who to ask for help on things. Just kind of going back further, it's a little bit of, proactive planning on it. It's, obviously I understand that's hard to do because a lot of times when you've got a child with disabilities, there's a lot going on. You're looking for services, special education, you're working with, all different kinds of therapies and whatever you've got going on. It's not that there's no priority, but it's important to kind of, as much as possible, pick your head up and not be surprised at the 18th birthday. Now what do I do?
Is there a way to get financial assistance for paying for the filing for guardianship?
I don't know. I don't actually have an answer for that one. I'm not sure if anyone pays for it or not.
I'm not aware of any. Doesn't mean it doesn't exist, but I don't know.
What's the first step to set aside a guardianship? How do I do that?
So when it comes to that, we're again going back to that restoration of capacity slide, the one with Mario Lemieux on it. The first step depends a little bit on the facts of the case. Depends if there's sometimes it's already gotten to the point of toxicity where the guardian and the person don't get along at all anymore. They've locked horns over and over again. The relationship has been destroyed. They can't even talk to each other without yelling and shouting. Unfortunately, we see that with some regularity. Or you might still be on good terms and everything's still cooperative, but we're just having this conversation. I think that depending where you are on that scale, you're either talking about having a conversation with your guardian because they might agree. They might say, hey, wow, you know what? You've really grown a lot. You're responsible. I know that you can ask for help when you need it. We've built this support network up around you that's going to last into the future. Let's go to court together. It can be done cooperatively. It doesn't have to be an adversarial thing if the guardian's on board. If the guardian's not on board, which again, it happens, some people disagree all the time, and sometimes they disagree strongly, then it's a matter of, if you have that conversation, or if you decide you just can't have that conversation, it's going back to the court, asking, the court rules kind of lay out the process. It's always a good idea to consult with an attorney, and disability rights can provide some basic guidelines here if anyone wants to call through. But it's going to the court and asking the court to review the guardianship, presenting the evidence to the court on why it's not necessary anymore, and reversing it that way.
Because of the pandemic, will the family be getting this done virtually or in person with the courts?
My understanding right now, we get bulletins, and let me tell you, we get dozens of bulletins. This is one of those things where from early March until now, things have changed like daily. Different courts are doing it different ways. My understanding right now, as of August 12th anyway, is that a lot of these hearings are done virtually, so that folks don't have to present physically inside a courtroom, and that way court staff, the individuals who are presenting, aren't putting themselves at too much risk of transmitting a virus. So right now I think it's all virtual, but that could change day to day. It's always important to check with the court wherever you plan to go.
I am the legal guardian. What actual power do I have to say no to something that the person I support really wants?
So for this one, I'd go back and I'd look at, the reason I put those two cases in. I know it's boring even for lawyers to really sometimes talk about cases from history like that. But those cases really outline when there's a disagreement between the guardian and the individual. And we're not talking about people, they weren't contesting, none of those people, neither Grady nor MR, were contesting whether they needed a guardian at all. They both generally seemed to think they were okay with having a guardian. At least they weren't putting that up as an issue in their cases. It was a specific question about whether, for one of them, whether they could consent to medical procedures. For one of them, it was who should they live with, who should serve as their guardian. And both of those cases, the court really outlined what should you do, who should we look to first. And in both of them, there's a pretty strong holding that says if the person themselves is expressing a wish and you want to disagree with that, if you want to do something different than that, and the individual expresses that wish so strongly that they want to take you to court, the court's going to be the decider on what should be done. And they're going to look through that standard of first looking to the individual themselves, and then, and only then, listening to evidence that that person doesn't understand the decision that they're expressing. And only if the guardian can provide that evidence in court would the court rule in their favor and say, no, individual, we're going to override your expressed wish.
I am in the process of getting guardianship for my daughter right now. Can I name a different person in the future?
So the New Jersey rules don't allow for any kind of forward-looking like replacement guardians. The only way the system works right now is that there's either guardians right now or there's no guardians. There can be co-guardians where 2 or more people are appointed to serve as a guardian. It's tricky because whenever there's co-guardians, they all share equal power. Nobody's the chief guardian or an executive guardian. They're all the same, which means they all have to agree on everything to make it work. So I always tell people, be very, very cautious if you're going to appoint a co-guardian or look for a co-guardian. That could, adding another person to the mix, it adds one more chance for there to be a disagreement or something that becomes dysfunctional. So proceed with caution.
How can we get a formal process for supported decision-making recognized in the state of New Jersey?
Yeah, so that's interesting. So some states have really done a lot in terms of putting all of this, what we have as an informal system, putting this informal system down into their law books. Texas, believe it or not, is really one of the front runners with formalizing the supported decision-making process, talking about when, professionals like doctors or lawyers can rely on a supported decision-making agreement to clear themselves of any potential liability for not getting informed consent. Setting up, even some of them even prescribe the forms that you have to use and sign, who has to sign them, who's allowed to be in the support network, who's not, whether they can be paid or whether they have to be volunteer. A lot of different states have taken a lot of different approaches. I would say that, if you're interested in having something like that here, the best place to start, contacting your state legislature, whether that's in the assembly or in the state senate, and having a discussion with your elected officials about, how they feel about it, whether they would support you in proposing something like that. There's good and bad to having something in the statute. Once there's rules, everybody follows them and everybody knows what they are. But if you don't like them, meaning, if they eliminate some folks from consideration from being part of a supported decision-making network, that might be something that works against your judgment. Right now, we're, like I said at the very beginning, we're not the Wild West, but we're kind of like the Wild West. There's a lot of freedom to do what you want in the supported decision-making world in New Jersey right now. I don't necessarily I don't think disability rights stands one way or the other in that right now. But I would tell you how to do it. First step, talk to your elected officials.
And I did share early on in the chat, I shared the supporteddecisionmaking.org if you kind of wanted to peruse that, see what other states are doing, see what looks to be working, what doesn't look to be working, just for your own background knowledge information.
Thank you. 2 questions pertaining to nonverbal individuals. How does this program work with a nonverbal person, and what are the options available for nonverbal persons?
Jill, do you want to take this one?
I guess I would kind of start with someone, although is nonverbal, may have other means of communicating. If they're using alternate forms of communication or any kind of assistive technology to communicate, choices, even the most basic of choices, I think I'd sort of start there with, what is that person's primary means of communicating with others? I'm starting from there.
I want to jump in with a war story from a little while back, but it's a case that disability rights handled for somebody who everybody assumed was nonverbal and in fact could communicate with sign language, but that was kind of hidden from a lot of different people. And once it came out, it's like, with an interpreter, this person can express all of their opinions and they're well reasoned. And it just turns out we have to understand what they're trying to say to us. So it would be, you don't want to short circuit it by starting with the most basic thing and saying that somebody's nonverbal. That may be true, but like Jill said, you want to make sure you've really exhausted a lot of different ways to make sure that person has every opportunity to communicate in a way that works for them. You know, there's all kinds of assistive technology, there's interpretation, sign language, people come up with their own signs. I mean, there's a lot out there that people use to communicate that's not the words out of their mouth.
Thank you. Does guardianship ever expire?
Not in New Jersey. Once you're in a guardianship, you're in it, or once the court finds you incapacitated, really, then you're incapacitated and the court says otherwise. Meaning you've got to go back to get the judge to order something different. So that means, you know, like I say, you get a guardianship for somebody on their 18th birthday, and over the next 10 years, they just kind of mature, as most 18-year-olds tend to do, on whatever course they happen to be on for themselves. You know, just because now they're 28 doesn't mean they can get rid of a guardianship without the court's approval. The same thing if they're 68 or 78. You know, the court would have to undo the guardianship once somebody's in. There's no ticking clock.
Is a power of attorney and a healthcare directive sufficient for a severely disabled individual?
It depends. It might be. Severely disabled, it's a pretty broad label. But if that person is appointing somebody else to make some decisions in those areas that they've put in their power of attorney, or medical decisions, if they've got a healthcare proxy, if they've designated somebody else that they trust, and that person understands what their wants and needs are, it could work. And then, you know, the bright side is that person could revoke them if they don't like the decisions that person's making for them. If, you know, they start consenting to procedures they don't want, they can override those decisions and revoke it instantly. You know, the person would have to, you know, at a very basic level, be able to, you know, sign the documents, understand what they say, and understand they're giving their powers to somebody else to make a decision for them. So it really depends on the, you know, severe disability doesn't tell me probably quite enough about that to say yes or no, that's sufficient or that's not sufficient.
Under what circumstances would a parent choose an alternative to guardianship?
I think you've got to listen to this whole webinar and you would know that.
Always. Start with always, and then
yeah. Guardianship should really be the last stop. It shouldn't be the first thing you do by default. And that's one of the reasons I was saying before, you know, think ahead. If you've got a child with disabilities and you're kind of worried what's going to happen when they turn into an adult, they legally gain the powers of an adult. If you're making a snap decision, all of the flow, all of the momentum in the state, you ask an attorney, what do you do? You're probably going to hear, go file for guardianship. You ask a parent support group what to do, it's probably going to be, go file for guardianship, because that's kind of the default. It's the only thing we have a law in the books about. But it really ought to be the last stop, because that's taking a lot of freedom, a lot of self-determination and dignity away from somebody else. It's you know, some courts would call it even like a civil death. The person no longer really exists as their own legal entity. It shouldn't be the first stop. And then later on you think about, what should I have done? Because when you're in now, you've got to find a way out. Before you get in, it's a lot easier to come up with a supported decision-making arrangement, whether, again, formal, informal, otherwise, maybe even use power of attorneys, medical proxies, you name it, to come up with other ways to make things work. And maybe after those all don't work, is when you start talking about guardianship. But I don't think it really should be the first stop, because it is so severely restricting.
I love and appreciate that you said that, Michael, because oftentimes, as I mentioned in the introduction, we hear firsthand that that's the first stop, the first choice, the first option. And I love hearing from you as a person, attorney for people with disabilities, that it should be the last stop. So thank you for clarifying that.
Of course.
Okay. Is it possible to have a financial guardian only?
Yeah. Yes. And that would be limited guardianship, like we talked about before.
Okay. I think I know your answer to this, but should people that have guardianship be seeking changes in it?
If they want to, I think that, you know, again, it's probably evident by now, I'm a big believer in self-determination myself.
Mm-hmm.
So I think that if somebody is just, you know, chugging along fine, if they understand what they've got and they're okay with it, okay, fine. If they understand what they have and they don't like it and they want something different, they should you know, take some action to fix that situation. And if that means I'm unhappy with my guardian and I want to do something about it, I think they should do something. And the thing I would tell you to do is, if you're really not sure where to start, go back to that slide that's up on the screen with our contact information, Disability Rights New Jersey, and you know, you can let us know, and we can try to provide you with some advice. I can't promise you we're going to take every single case that comes through intake, but I can tell you we'll give you some advice and at least point you in the right direction to get you started.
Okay. And here are two questions pertaining to supported decision making. The first is, could you address how supported decision making practice evolves over time, and what is the proper situation for supportive decision making?
The last, I'm going to work backwards. The second part of that question is a little vague, and I'm not sure that I can answer it. You know, what is the proper environment? It's you know, you really have got to look at the full picture for any individual, what they need and what they want. But evolving over time is a really good question. That kind of, you know, going back, and Jill's examples are really good. They illustrate such a good point about, you know, everybody uses supported decision making, and everybody's support network will probably change over time. You know, when you're a baby, you don't make any decisions because you can't express yourself. You don't know that the lights are on, the lights are on. You know, you're totally oblivious. All you know is that you're hungry, you need your diaper change. And then when you're a young adult, you get lots of guidance from or when you're a young child, you get lots and lots of guidance from your parents. And, you know, that might fade or that might not fade as you get older because your family structure works a certain way, your culture works a certain way. You know, it's really particularly specific. And that might continue to evolve as you grow out of adolescence into young adulthood. You know, you may turn to different people for your support. You may turn to friends or spouses instead of your parents, who are kind of your starting supported decision makers. You might turn to clergy, or you might turn to colleagues. And then as you age even further, maybe you start looking to your own children to help you make decisions, because the world has changed since you were, you know, a middle-aged adult and you don't understand things. And like there's naturally, for anybody, regardless of whether or not they identify as a person with disabilities, their support network is going to change and evolve, and it needs to change and evolve along with you. I mean, it's something that applies, you know, when you have something formal, you may want to even think about, okay, how will this look in 10 years? Do we revisit this every year and have a meeting with all the decision supporters, and talk about, you know, hey, do we need to update who's in the loop here? If it's informal, maybe it happens a little bit more organically, and that's again, that's one of the nicer things about not having a statute. It's one of the pros, is that you can kind of adjust it on the fly. You don't need to follow any particular process. It's what works for you.
And two more questions before we get to the chat. In general, how long is the application process?
That depends. It really depends on if it's contested or not. It could be, you know, weeks or months. Nothing in court is fast, I can tell you that.
Okay, and then the last question here is, I'm not sure pertaining to this whole, but it's along the lines. When and does the payee hand over stimulus checks to a guardian, and which type of guardians can receive those stimulus checks? This is in relation to the pandemic.
Okay. When can the rep payee, so it's a Social Security representative payee we're talking about, I assume.
They don't indicate.
Yeah, I would have to guess that. And my understanding from talking with we have a representative payee review team at Disability Rights New Jersey, and they work on reviewing representative payees' actions to make sure they're doing what they're supposed to do under the law and reporting back to Social Security on it. I've talked to them a little bit about this because it was a hot issue, especially when those checks were being issued, you know, a couple months back. My understanding is the representative payee actually doesn't have any authority to do anything with those stimulus checks because it's not Social Security money, and that it has to go directly to the person. And, you know, I guess kind of the logical next step would be, if the person has a financial guardian or a general guardian, that person would be responsible to manage the money the same way they would manage any other non-Social Security money. The big takeaway is that I don't think the payees have much to do with that money, other than if it lands in that account, hand it over.
Okay, thank you. That's all for the pre-submitted questions. Zinke, would you like to address the questions that have come up in the chat?
Absolutely. Can everybody hear me?
Yes.
Okay. The first question is, when a parent has legal guardianship and the adult child lives in a residential home and has a state-appointed advocate, what is the course of action when the parent has been denied to see the child or to see what is going on? Sorry, just lost the end of the question here. What is going on with, I can't read the rest of the chat, it keeps disappearing. What is going on?
Zinky, I'm going to stop you because there's enough ifs and whens in that one. It's a really specific kind of question. It's not the kind of thing I would want to talk about in a public forum. And no offense to the question asker on that one. I'm not saying it sounds like an important question, but it's so specific that I think we'll delve into giving you legal advice. And I don't want to do that here. I think it's a little too public for that.
Yeah, again, and I would reiterate for anybody who maybe had a question that didn't get it sufficiently answered, or if, we give that kind of packed answer again, to email more specifics to our advocate email or to give us a call, and we can talk in more specifics.
Yeah, I echo that 100%, Jill.
Okay, next question. Does an incapacitation determination have a short versus permanent period? In other words, if someone has a TBD but recovers relatively well, can that status revert?
And yeah, I think this kind of plays into is there an expiration date? And I think the answer is not by default. There's not going to be anything unless somebody goes back to the judge. If somebody had an incapacity finding and things have changed, but yeah, TBI is a good example where, maybe even a short course of time, the brain recovers from the injury, and that person's capacity can really measurably change in a very short amount of time. That person would have to go back to court though, and have the judge undo the capacity finding with a new set of evidence.
Okay, next question. My daughter graduated high school in 2018, aged out of DDD. I must resubmit when she turns 21.
Or submit for services or guardianship. I'm not sure if that question is
right.
Was directed
Maybe
at.
Angelica, you could send a new message and we'll catch it at the bottom of the feed and clarify for us. Okay, the next one from Mona says, can two people be guardians at the same time?
Yeah, I think I answered that one with the co-guardianship. Two people can be appointed. They need to agree with each other whenever a decision gets made. It just adds another party to the mix, but it's possible and it's relatively common.
All right, back to Angelica. Turns out she was clarifying just a few moments later in the feed. Continued, should I wait till she is back in DDD to start guardianship stuff?
That it's these specific ones, I don't want to dive into them because we're starting to talk about, when should I do something? And that's really a request for legal advice. I'd say that, to the extent that you want to ask that question and get something a little bit more specific, you can call us. I'm not sure that, helping somebody get a guardianship is well within our priorities at Disability Rights New Jersey, but we can always point you in the right direction to get the advice if it's not something we'll give directly.
And I don't think that being a recipient of services from DDD automatically makes someone eligible for a guardianship. So they're two sort of kind of separate. And unique.
Absolutely. Okay, so if a parent has guardianship over someone and the individual wants it reversed, how can it be reversed? Parent became the guardian at age 18 of the individual who is now 32.
Yeah, we've covered that one a couple times. I don't want to repeat it and dry everybody out from my voice.
Let's slide with who is it? Mario.
All right, and then some good information. Here's a second one from Jill, a YouTube. And then I think you covered this as well. Do you have to renew guardianship agreement?
You have to renew one? No, yeah, no. Once they're in until they're changed by the court.
I I'd just like to jump in and say that I have met with some families over the years who have said that they've needed to have something recertified down at the court each year.
Yeah, sometimes a lot of courts will do annual reporting where they'll require, especially if there's any kind of money. So, you know, for somebody who has perchance a trust fund, or they've got significant assets of their own, and the guardian is going to be managing a good amount of money. You know, courts deal with money. It's, you know, it's the kind of thing the legal profession can understand pretty easily. So, you know, liberty and decision making maybe don't ring always quite as strong as dollars and cents. And if the guardian mismanages money, it's gone. So some courts will ask for guardians to put annual reports in, basically come back to court every year and file an annual report, so that the court can monitor. Since that power, the history lesson is, maybe I'm glad I really went into it a little bit. The power comes from the state. It's the state taking care of its, quote, children. The state is overseeing the people it appoints to do that job to make sure they're doing a good job. And that's where that annual reporting comes in. It's the court keeping an eye to make sure the guardian's managing the money okay, not blowing it all, not losing it in this, you know, the stocks or things like that. And that's a way just for the court to keep an eye out. Some guardianships don't have that kind of requirement. Some do. It's up to the judge who writes the order, whether they think it's appropriate. Some judges, and it's perfectly allowable under the rules, some judges will also require annual reporting as to the person's well-being. You know, what have you done this year to help them work towards restoring their capacity? How are they doing? Where are they living? And the court's really take a more active role. Not everybody, again, it's probably a little bit more rare, but that's something where the courts can do a check-in. And I guess presumably if the court heard something bad in that annual report or didn't get enough annual reports in a row, they might say, uh-oh, I've got a problem with my guardian. I need to appoint somebody else to come in and take a look here. But generally speaking, yeah, that doesn't really happen all that often.
Thank you. That sounds very helpful. Kind of like a little quality assurance there, at least.
Mm-hmm.
Mike Steinbrock has sent a link for everyone, courtlistener.com. And the next question is, does self-determination of what is best apply to someone who is nonverbal and has been determined by the court as incapacitated?
I'm trying to understand that question, and I apologize because my chat reset when the power flipped off. So these are probably all the ones that came in before I got back online, so I can't read it.
So she's saying the person is nonverbal and determined by the court as incapacitated. Is self-determination, does that apply to that person? Oh,
yeah. It's actually, believe it or not, an easy answer that you said it that way, Zinky. Yes. The statutes that I went through that talk about the things the guardian shall do, they're all things the guardian shall do regardless of whether that person's incapacitated. I mean, obviously the guardian only does something when somebody's already incapacitated. So those all apply, meaning, you know, to the extent possible, maximize self-determination. To the extent possible, build a capacity. You know, even though I've got my bias towards self-determination, I'm also, you know, I see clients, I live in the real world. I talk to a lot of different people with all kinds of different disabilities. And, you know, there's certainly some folks who even with all the assistive technology in the world and, you know, the best interpreters in the world and speech therapists can't express enough to express an opinion on everything, right? Or sometimes on very, very little at all. And for that, it's, you know, it may be difficult or impossible. So that's why a lot of those things say to the extent possible. I think there's an onus in the guardian to show they're doing that. It has at least tried, hasn't just written somebody off. You know, like I said before, we've had the client who was nonverbal, but turns out completely able to express herself once provided with the right kind of interpreter. It's just a matter of making sure you've kind of gone through that to make sure you've tried everything you can do to follow those rules.
Okay. My child just turned 17. When does this process begin?
I think we've covered that one too. I don't want to go back too much.
Right. Okay, and okay, I'm sounding like John during the updates right now. Let me see. Okay, can you still make decisions, medical, residential, legal, for your loved one, even if you are not a legal guardian? Is it necessary?
So, you know, making a decision for someone, and this is a good question. It brings up a good point, Zinke. I think I like this one. So if that person has given you some power of attorney to make a particular decision, like that's a legally recognized way for somebody to give another person the power to make a decision for them. But otherwise, if the person's not incapacitated, they ultimately make all their own decisions. So if they don't like the decision their power of attorney made, you know, snap their fingers or follow the instructions in the document, and that power of attorney can be revoked. And that power of attorney no longer has any powers to make any decisions, because ultimately, outside of the incapacity context, the individual retains that decision-making power. So it's worth putting up a little, you know, red flag in the supported decision-making world. A lot of times you'll hear the word supported decision maker, and it's kind of your ear should perk up if you hear that, because if you hear supported decision maker, the supported decision maker, the person making the decision, should be the individual at the center. It's the person with disabilities in my case. I wouldn't hire or incorporate, you know, my mom as my supported decision maker. She wouldn't be the one making any decisions. I might call her and get her input. I might even have her help communicate with me, but ultimately the decisions would be mine. If I were the supported decision maker, they'd be mine, not the supported decision network around me that helps me make that decision. It's an important distinction. But otherwise, you know, the shorter answer to that question is, you know, yes, if there's a power of attorney that's already been drafted and signed.
And just thinking sort of outside, I'm sorry, this is my non-lawyer answer. It's just, you know, in the absence of any formalized or legal, you know, setups, your family member, your loved one, your friend, you're making decisions with a person, or, you know, helping a person to make their own decisions. And so thinking of it in terms of that instead of making a decision for someone, which is very paternal.
The next question is pretty similar to content that we've already covered. So I don't know. I think this is from Rebecca. How does guardianship differ from power of attorney? Are they usually appointed to the same individual, or should I just look into both more from a legal standpoint?
I did share in the chat, we did a, mentioned before, did a webinar earlier on in the summer specifically about healthcare proxies, power of attorney, other advanced planning kinds of situations. So anyone with questions, I think, that are more specific to those topics, feel free to take a look at that.
Great. Thank you for that, Jill.
Sure.
Next one. New York State offers training for people who want to become guardians in the public sector. Does New Jersey have this as well?
I don't know of any for the average person to have access to. I think you'd have to go seek out your own training. I don't think there's anything state sponsored. Jill might know more about it. I don't know if you know of anything, Jill.
I do not.
Okay. Couple of comments. Okay. What happens when a guardian passes away and the person has a disability?
So this also happens with some regularity, and it's a product of, you know, the system we have. None of the rules provide for a standby guardian for adults, meaning you can't set somebody up to be the next guardian in line. Again, using my little history lesson, the power always resides with the state. So when there's no court-appointed guardian to serve, the power goes back to the court. Now, the big problem is the court may not know that the guardian's passed away, and if nobody tells them, there's no way for the court to either go back and say, okay, let's look, does this person still need a guardian? Okay, maybe they still need one. Let's find somebody to serve as the replacement guardian. If the court doesn't know, nothing happens, and that person may not have a guardian for a period of time. That's not uncommon with this system. Usually it's a good idea, if you are serving as somebody's guardian, let other people know about that. Have somebody in the loop who can, you know, step in and notify the court. Maybe that's another loved one, maybe that's a lawyer, maybe that's you know, a service professional who you know is going to be around. Those are the kind of places to look. But yeah, that can happen where somebody passes away who's serving as guardian, and you know, there's not an automatic replacement. If there's co-guardians, I've talked about some of like the cons of co-guardianship before, where you have multiple people who must agree now. A co-guardian, if one of them passes away and the other one remains living, the other co-guardian stays on as guardian. You know, presumably they'd have to go back and report to the court to update the records and everything, but they would still be able to exercise all the appointed powers that the court had given them, and you know, exercise all the duties as the guardian too.
All right. Is there just medical and financial power of attorney?
The great news about power of attorney, you can go, again, echoing Jill, she said she put the link in the chat box for our power of attorney and medical healthcare directive webinar that we did a little while back. It was during COVID, so not too long ago. And take a look at that for some specific details. But the good thing about powers of attorney is you can really tailor them to fit your needs. You can give people a lot of different powers, lay them out specifically in a document, and write it down what you want someone to do or not do for you. So you can kind of mix and match and make it what you want it to be. I would also have one more thing I want to tack on there. If you're considering drafting a power of attorney, highly, highly, highly recommend consult with a lawyer. Make sure that you're doing it in a way that will work for you, that you're not doing something. Again, it's easy. You're allowed to do a power of attorney. It's easy to write one and sign it. It's hard to know whether you're about to step on a landmine that you didn't even see coming because you don't have experience in that area. Talking to somebody, a lawyer who does a lot of powers of attorney, and there's plenty of those guys around. Generally, it's not too expensive to consult with somebody in a power of attorney. It's a good idea to do it so you are talking with somebody who's seen hundreds of them and has seen what happens when there's a problem and can advise you, okay, you're about to step in a landmine, here's what I'd recommend doing instead, or as long as you're aware of it. Really, that way you go in with eyes wide open. Like, you can draft it yourself. You're perfectly allowed to. It's not hard to do. It's also, you know, one of those things without experience, you may not even see a pitfall that you're about to fall into.
Well, if a guardian is not making the best choices for an individual or not spending their money correctly.
Yeah, so that's when you go back to the court rules on reviewing the guardian's decision. So if somebody's got a concern, in particular, if it's the individual subject to the guardianship who's got a concern about how their money's being spent, they can write to the court under those rules and ask for the judge to call everybody into court and review the guardian's actions. It's something that can be done on an individual decision. It can be done just a general, I've got a concern. The rules are good in that they provide for the court to always be able to check when there's a request, what's going on with this guardianship.
How do you find an attorney that handles partial guardianship power of attorney?
For most questions that come from a how do you find an attorney, the best answer I come up with, and even from my days before I worked at Disability Rights New Jersey, when I was in private practice, the county bar associations, all of them operate a lawyer referral service. And I have to say that, like I said, from my days before DRNJ, they were one of the greatest ways to connect with clients who are looking for your services. So the county operates basically a directory of attorneys and keeps track of what kind of things those attorneys handle. Only reputable attorneys are allowed to be in the directory. And it's a good way to check in. I'm looking for help with power of attorney, or even as drafting a will, or I've been in a car accident, whatever that happens to be. The County Bar Association Lawyer Referral Services are a great place as a first stop, and get a couple different names and numbers of attorneys who do good jobs. Interview with them, see who matches up with you as far as fees and personality and experience and all that good stuff.
And I just put the link for the lawyer referral in the chat for people.
Okay, and I also would like to throw out NAELA, which is National Association of Elder Law Attorneys. And you can look up an elder law attorney on their site. Okay, the next one, it's from Jill with Dilly, a plethora of information. This is the New Jersey Court website, information about guardianship monitoring, That was not right now. That was about 45 minutes ago. Okay, here we go. How much time does it take to get guardianship once you apply? I think we kind of covered that already.
Yeah. And now I think I've caught up with the chat too. I think it's now back to the point where I was back online.
I'm at 2:22.
Yep.
Oh, and Mom is asking, pretty much we've already covered this question from Mona. What happens if I'm the guardian and I pass away? If you move out of state, do you have to go about the process again to get another guardianship? Ooh, that's a good one.
That is a good one, and it's one that I am not qualified to answer. I only practice in New Jersey, so other states may have different laws about whether or not they would recognize a guardianship that was started in New Jersey. I would say if you're going to be moving out of state, you want to know that answer, consult with an attorney in the state you're moving to. See how they recognize out-of-state guardianships. It could differ depending where you're going.
Okay, can an adult have a power of attorney and a guardian at the same time?
No. Once you have been found to be incapacitated, and if you think about it, it starts to make sense. If a court has found that you're incapacitated, that you don't have the legal capacity to make your own decisions, then you can't appoint somebody to act on your behalf because you no longer have that power to give. That power has been taken away from you and given to a guardian. And a guardian can't necessarily, I think the answer is generally cannot appoint a power of attorney. They've got to act on your behalf directly. So any old power of attorneys you had generally are revoked once you've been found to be incapacitated, and you couldn't make a new one after you've been found to be incapacitated, you know, until and unless the court finds that you've regained your capacity, and then you could go back to making them just like before.
What can be done in a situation where the guardian is the attorney and has no personal interest in the person's best interest, whom they are the guardian of, and is very much hands-off and impossible to get a hold of?
Yeah, so that happens a lot of times. You'll see when somebody doesn't have any family around, they don't have any distant relatives or friends even who could serve as the guardian. They don't have a lot of folks around them, but they've been found incapacitated. A lot of times courts will appoint an attorney from the local bar to serve as a guardian. The answer, though, doesn't necessarily matter so much, and that is if there's a problem with how the guardian is operating, regardless of who they are, who's been appointed to serve as guardian, the power always lies back with the court. And following those court rules about asking for court review, going back to the judge, it's a little bit of tattling, but sometimes you got to stand up and self-advocate and say, I've got a problem with my guardian. They're not listening to me. Here's all these different statutes. I've kind of laid out those statutes. They're supposed to be working with me, listening and respecting my decisions, but I can't even talk to them. How are they going to respect my decision? That might be a time to go back to the judge if you've really got a problem with the guardian. And that way the judge can exercise his or her authority to fix the situation, whether that's with a replacement guardian, whether that's with some specific instructions for how the guardian should communicate with you. There's a lot of different things. The judges have some wide latitude to fix problems that way.
I'm sorry to interrupt you, Zinke, but this is Amy. That was actually my question. Thank you for reading that. And somebody's messaging me privately, and it's along the same lines of the question I asked, actually, and they're asking me to ask it out loud on their behalf. And it says, what if a person has a guardian who is completely missing in action? We don't know where she is, can't get a hold of her, never hear from her, and monthly checks are sent on auto pay, which are oftentimes less than the money that the state's actually sending her, and it's caused her to lapse in Medicaid. And I have seen this in a few instances where the guardian is not possible to get a hold of. And as you mentioned in the last answer that you had, Michael, is the state would assume guardianship at that point, but who initiates that? So if the person, let's say, for example, is unable to speak or advocate for themselves and their guardian is not available, who is the person that brings that attention and information to the court system for them?
So that can be any interested party. So there's nothing that stops. It kind of sounds like that question was coming from a service provider based on the checks.
I think they are, yeah.
So, there's nothing that stops an interested party from writing to the court and letting them know about a problem. That party may not have any stake in ever becoming guardian, Maybe they have nothing, they have no interest in becoming guardian themselves, but they just want to let the court, hey, you've appointed somebody and they're not doing their job. It's a rare judge that wouldn't take that seriously and on their own start the process for calling the guardian to court, having a review. And if they can't get in touch with the guardian themselves, saying, oh, we've got a problem here. We need to, again, use kind of the wide discretion of the court to fix that problem.
Thank you.
It
Would
doesn't have to
DRNJ,
be.
I'm sorry.
Go ahead.
Would DRNJ be able to point in the right direction on who you contact at the courts to start that process? Would we contact you?
Yeah, so it's actually a general answer would probably work here. Every county has a county surrogate, called, usually referred to as the surrogate's office, or sometimes it's the they're found within other departments of the county, and it depends which one of the 21 counties you're in. They all work a little bit differently, but the surrogate's office typically is the contact point for any of the guardianship judges in the courts. They essentially act as the clerk of court for guardianship and other surrogate matters. Like, for us, it's really just guardianship that we're worried about, so we'll stick with that. But the surrogate's office is usually easy to get in touch with. They generally tend to be very helpful in explaining the process, who you write to, what forms you have to use, if you have to use any forms, what rules to look at. They can't give legal advice, but they can at least give you an idea, like, where should I send this to? Who should I send this to? How do I address it? Things like that. If you're really concerned, consulting with an attorney is always recommended, because that way you can get somebody who can give you actual legal advice that you can lean on. And if somebody specifically has a problem, especially if there's any allegations of neglects, as Jill kind of started off at the very top, that's one of our core issues at Disability Rights in New Jersey. So we want to make sure if there's an allegation of neglect against somebody with a disability, that we hear about it. We address them all different kinds of ways depending what's going on, but it's something we would want to hear about, I think.
Thank you.
Thank you. Does DRNJ advise on special needs trusts?
No. If you've got a question about special needs trust, that's well outside of our wheelhouse. There's a large private bar that handles those kinds of things. You definitely want to consult with an attorney. They are very complicated. That's one of those things that's not even easy to write. So it's, you probably need an attorney, even though you're allowed to do it yourself. You probably need one to do it right. But Disability Rights doesn't do that as part of our representation.
I know we're running out of time. I'm going to try and squeeze in one or two more questions, but before I do that, I'd just like to throw out that one of the questions is regarding the chat. And yes, that will be, I believe that will be sent along with a recording and the PowerPoint slides if you're an attendee and you've registered. Okay. With regards to the question, when should a parent pursue legal guardianship? If they will be applying for DDD services. Some suggest that families wait until their son, daughter are found eligible for services through DDD, since she is entitled to a public defender as a DDD client. The incapacitated person has to be represented by an attorney. Clients are not DDD registered, have to pay private attorney. Okay, so there's no, I'm not really sure if there's an actual question. I think it's at the top of the feed there. When should a parent pursue legal guardianship if they're applying for DDD services?
Yeah, I think that person's trying to answer a question that came up earlier.
Yes.
So I'll let that stand. Won't adopt
Sounds
it.
good.
Yeah.
Okay, and Jill's sending more awesome info. Does a guardian have to be a legal United States resident?
That's a good question. That's a novel question too. I don't think I've ever looked to see whether you must be a United States resident legally present in the country to do it or not, to serve as guardian. I don't know. I do know one thing that maybe kind of tangentially answers this question. Remember I said before, courts ask for regular check-in sometimes, especially if there's money involved. The person who is now incapacitated had some kind of money on hand, anything really measurable, more than, say, Social Security. They might ask for an annual check-in. Sometimes courts will also ask guardians to put up a bond, basically to buy an insurance policy that if they do something silly with the money and lose all of it, that there's an insurance policy that will reimburse the person, and the guardian must pay the premium, basically. It's a really simplified explanation of a bond. I don't think you could get one of those, get a bond, if you weren't in documented status. I don't think it would be couldn't do too much banking, I don't think, without a valid social security number. So to that extent, I don't think so, but I don't know if the rules actually address it or not. I could take a closer look, and I have to get to that person offline if they want to give us a call later.
With that, we have finished our questions with 60 seconds to spare.
Wow.
Right in the nick of time.
That was because there was so many awesome questions and such an awesome topic.
There were really great questions.
Yeah, I want to thank everybody who came, all the participants, people who asked questions, Zinky and Amy for doing all the legwork to set everything up here for us to present. It's always really, I find it fun. I'm a little bit of a dork, but I find it fun to talk about this stuff and to hear the different questions people have and engage. It helps us make sure that we're staying grounded and responding to the concerns that people have. So thanks to everybody.
And thanks very much, Pam, for sharing your story and for your input. It's always valuable to hear firsthand from someone instead of all of us on the periphery.
Kudos to Michael for doing 2/3 of this with no power.
Yeah.
Right? The rest of us are in air conditioning with some lights on, so kudos to you for going the extra mile.
Yeah, we appreciate you guys. Thanks so much for doing this in collaboration with us.
Thanks for everyone for taking 2 hours of your day to listen to us.
Yeah, thanks for everyone being here. Yay! Keep love for everyone.
All right, take care, everybody.
Have a great rest of your day, folks.